Be debt-free in 100 days. Introduction. This special report has been written to educate natural men and women to highlight the fraudulent nature of the global financial system and offer solutions to those who may be experiencing financial hardship as a result of it. In this program, I provide valuable resources and hope to offer unique insight into dealing with debt by acting honestly, lawfully, and truthfully, which does not follow the advice of debt counselors, credit bureaus, banks, or financial advisors. Learn how the banks and the courts conspire to rob you of your money. Learn how debt collectors intimidate you and trick you into contracts, and learn how to empower yourself by using some strategies and simple rules. Truth and openness. I have nothing to fear from truth and openness. I love truth and openness, for it exposes lies and deceit. We do everything openly. They whisper behind closed doors. I live in the light. They operate in darkness. The light has shined in the darkness, and the darkness can never put it out. Why release the debt on your credit card or other debts? There is no need to let the banking industry take advantage of you any more than they already have. This economy is not your fault. The real estate market downturn is not your fault. And, more importantly, your loan was paid in full the day you took out the application to get the credit card. How banks create money. Banks create money by demanding deposits or book entries that reflect how much lawful money the bank owes its customers. The bank's assets are cash plus IOUs and promissory notes that the borrower signs when they borrow money or cash is lent. Example, if a bank has 10 people deposit $5,000, totaling $50,000 in cash, legal money, and the bank's reserve is 5%, then the bank will lend 20 times this amount, or $1 million in credit money. What the bank has actually done, however, is loaned its credit with the purpose of circulating credit as money. The bank knows if all 20 people come at once demanding their money, the bank will close its doors. The bank creates the illusion it has lots of money or credit so it doesn't cause a panic. Notice, the Federal Reserve Bank of Chicago in its booklet, Modern Money Mechanics, page 3 states, in the United States neither paper currency, example Federal Reserve notes, nor deposits have value as commodities. Intrinsically, a dollar bill is just a piece of paper, deposits merely book entries. The acceptance of said currency is merely a confidence game predicated upon the people's faith or confidence that these currencies or instruments can be exchanged and accepted for goods and services. Individuals have been stopped from using and have no access to lawful constitutional money of exchange to pay debts at law and pursuant to HJR-192, can only discharge fines, fees, debts, and judgments dollar for dollar via commercial paper or upon individuals' exemption. See U.S. Constitution, Article 1, Section 10. What is a loan agreement? The bank advertises that it loans money. Then it says, sign here. But they don't sign because they're not loaning their money. They are just collecting a note that acts like money. In a mortgage transaction, the bank receives the equity of your home for free, in exchange for an unpaid bank liability that the bank can't pay without returning the mortgage note. The bank receives your mortgage note without investing 1 cent. Then it sells the note for cash or an asset that can be converted to cash. Example, a person wants to borrow $100,000 to purchase a property. So the bank issues a $100,000 liability or note. The $100,000 is a lien placed on the property the bank received without investment. The bank never puts up any money. The alleged borrower effectively created money by signing the promissory note. This note acts like money. So the bank deposits your mortgage note as money, which to issue a check. Then this check acts like the real money the home seller or builder receives. The fraud. The bank effectively made you a depositor, not a borrower. Your promise to pay gave value to a note that the bank sells to a third party to realize legal money. No actual loan was generated from the transaction. One cannot repay which was never loaned in the first place. Related case law. We are aware and know that the use of a Federal Reserve note is only a promise to pay. See Fidelity Savings v. Grimes, Volume 131, Pacific Reporter 2D Series, page 894. We are aware and know that legal tender, Federal Reserve notes, are not good and lawful money of the United States. See Raines v. State, Volume 226, Southwestern Reporter, page 189. We are aware and know that Federal Reserve notes do not operate as payment in the absences of an agreement that they shall constitute payment. See Blackshear Manufacturing Company v. Harrell, Volume 2, Southeastern Reporter 2D Series, page 766. Peace of Mind, LLC is a company that partners with clients to provide the documents and process of service steps necessary to accomplish your agenda. We joint venture with you to streamline the process by providing you with the information you need and then doing the documents for you. Summary of just some of the steps involved. Send a copy of your credit card or debt statement to see if you qualify. Sign partnership agreement. Formulate a strategy depending on your situation. Prep docs to send to the lender. Send demand letter docs to lender. File forms with the IRS. Enforce liens on lender. Important legal facts. The Uniform Commercial Code, UCC, first published in 1952, is one of a number of uniform acts that have been promulgated in conjunction with efforts to harmonize the law of sales and other commercial transactions in all 50 states within the United States of America. The UCC provides a uniform law designed to simplify and modernize the consumer credit and usury laws, to further consumer understanding of the terms of credit transactions and to protect consumers against unfair practices. Any transaction to discharge a debt liability is in accordance and compliance with UCC 3-104, Title 4, Section 401 FRA, USC Title 12, USC Title 28, Section 1631, page 3002, and the Foreign Sovereign Immunity Act under necessity. Everything since June 1933 operates in commerce. Why is this important? The Congress of the United States did legislate and provide the American people a remedy or means to discharge all debts, dollar for dollar, via HJR 192, due to the declared bankruptcy of the corporate United States via the abolishment of constitutional coin and currency under executive order declared by then-President Franklin Delano Roosevelt. HJR-192 superseded public law, replacing it with public policy. This eliminated our ability to pay our debts, allowing only for their discharge. Note: the U.S. bankruptcy is verified in Senate Report Number 93-549, 93rd Congress, First Session, 1973, Summary of Emergency Power Statutes, Executive Orders 6073, 6102, 6111, and by Executive Order 6260 on March 9, 1933, under the Trading with the Enemy Act, 65th Congress, Session 1, Chapters 105, 106, October 6, 1917, and as further codified at 12 U.S.C.A. 95A and B as amended. There are numerous references to case law, legislative history, state and federal statutes or codes, Federal Reserve Bank publications, Supreme Court decisions, the Uniform Commercial Code, U.S. Constitution, state constitutions, and general recognized maxims of law which establish that the law coin, i.e. organic medium of exchange, and the former ability to pay debts has been replaced with fiat, paper currency, with the limited capacity to only discharge debts. That the Congress of the United States did legislate and provide the American people a remedy or means to discharge all debts dollar for dollar via HJR 192 due to the declared bankruptcy of the corporate United States via the abolishment of constitutional coin and currency. See Appendix E. The bottom line to release your debts. The bank is not the creditor. You are. Without being the creditor, the bank has no rights and cannot do anything except comply with your demands. Your job is to put the burden on the bank to prove they are indeed the creditors. Prove they indeed hold an actual note to your property.